case briefs, and so much more. LSData's got what you're looking for.
In the 1989 case of Green v. Green, the Supreme Court of Rhode Island addressed the question of whether funds in bank accounts, set up as totten trusts by George Green for his heirs, should be distributed to the named beneficiaries or divided under intestacy laws. The court was presented with a conflict between Green's wife, the plaintiff, and his 3 children from a previous marriage, who were named as beneficiaries in the trust accounts. Green had established the trusts with the intention of transferring assets to a named beneficiary after his death. In a totten trust, the beneficiary is not required to accept or even have knowledge of the trust beforehand. To determine the validity of such trusts, the court considers the intent of the person who created them. The trial court found that Green had indeed created the accounts as valid totten trusts, and held that the funds should be properly distributed to the named beneficiaries upon his death. The plaintiff appealed the decision, arguing that the funds should go to her, rather than being divided among Green's children. The Supreme Court affirmed the trial court's decision, emphasizing that trial justice findings are given significant deference and can only be overturned if clear evidence of error is present. In this case, the court determined that George Green had created the accounts with the intention of distributing them to the named beneficiaries, and thus ruled that the funds should not be distributed under intestacy laws. The plaintiff's appeal was denied and dismissed, the judgment of the lower court upheld, and the named beneficiaries, including the plaintiff, were entitled to the funds in the trust accounts. With the decision endorsed, the case papers were sent back to the Superior Court.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.